back to you on a completely different issue, but one that really comes up all the time, and that is the one of remuneration, and the question that we sometimes get as to how should one make sure that you determine remuneration within an organization in a way that is defensible.
Yeah, perhaps before I get to that specific item, I think what is important, and perhaps to tie together some of the items that we've just discussed. You touched on a very, very pertinent aspect of the approach of King 4, and that's the integration and the integrated approach. Now, I think what's very, very helpful, and again, this is now the attorney and me speaking, trying to always find the legal basis for how you do this and how you approach this, is to understand how the legislation and King report works together and requires directors to approach the implementation of corporate governance. And that is done on 3 levels, and I think it's important to distinguish them, and that each one have their own specific requirements. The first one, as I've already mentioned earlier, is the Companies Act. Now, what is interesting with our new Companies Act is that it has introduced a concept, although new to the Act, not entirely new to our common law, which is essentially called, for just practical purpose, the business judgment rule. Now, the business judgment rule is a development of common law in essentially court cases, where courts have tried to establish whether a person who acts in a fiduciary capacity has complied with their obligations. In other words, did they comply good corporate governance? And it's interesting, if you look at how the test is set out in the Act, what it requires. Obviously, there are the usual things that one would expect for a director to bear in mind, and that is to act in the best interests of the company, and to act with the necessary care, skill, and diligence. Those are the things that, from a normal common law perspective, we understand. However, it now brings in a level of subjectivity which is very, very interesting, because it says that the business judgment rule will apply under circumstances where a director takes a decision where someone in the same position in a similar company would have taken the same or similar decision. So it immediately makes the test subjective. And secondly, it is based on that specific director's level of experience and knowledge. So the first thing to obviously bear in mind there is that the test of complying with corporate governance requirements has become subjective. And that is why the King 4 Code is drafted in the way that it is, because it needs to make allowance for people to be able to come to essentially different decisions under fairly similar circumstances, because their circumstances within the company or their knowledge and skill may differ. So that's quite an important aspect to bear in mind, and that's where the legal basis of this comes in, because the Act then goes further and says that in looking at a director acting under those circumstances, there are a number of factors that will be taken into consideration, but 2 of them are quite important. The first one, did the director take the necessary steps to inform himself of the situation? Now, inform can obviously have a very, very wide interpretation, but that essentially means, did you go and investigate what the effects of this decision would be? Did you look at the items by implication prescribed by the codes? Did you look at the stakeholders, etc.? So, in applying the business judgment rule, if you want to be able to justify your decision, you must be able to show that you did investigation. And number 2, the other important factor is that there's a rational basis for the decision. So again, no matter what the outcome is, as long as there's a rational basis, you can say, well, this is the basis on which I did that. And again, this is where King 4 creates the mechanism to do that, because we've not touched on it, and I think it's quite an important aspect. Under the King 4, the requirement for directors to comply with their duties is to apply and explain. You have to explain why you are doing certain things under certain circumstances, and that explain becomes the rationale for the director, i.e. that's your compliance with the provisions of the Companies Act, where you now say, okay, these were the circumstances, this is the basis upon which I took the decision, and therefore it complies with the rationality requirement of the Companies Act. So there is certainly, from a Companies Act perspective, a requirement to investigate and to comply and to be able to defend the decision taken. And there's a certain level of subjectivity that will always come into this. So that's one aspect. The second aspect relates to accounting and financial statements. Now here, I think with due respect to my colleagues who are auditors, we differ in our approach. But what auditors do, and what makes things a little bit easier from that perspective, is that in preparing financial statements, they have a huge number of accounting standards that they must comply with. And a huge number of them are reliant on some of the aspects that will flow from a corporate governance document such as this. But indirectly, directors have to deal with that, because if you are a director and financial statements are prepared and the accounting statements require you to make certain disclosures or to comply with certain requirements, then certainly that must be done from that perspective. And that is certainly the second way, or the further way in which King 4 principles become relevant to any director in a company, because not only do you have to comply with the Companies Act, you also have to be able to comply from a financial perspective and to make sure that the company's financial statements comply with those requirements. We've referred a little bit to integrated reporting, and that is, again, another theme that is fairly emphasized in the King report. Integrated reporting means that you do not only report on the financial aspects, but you look at your environment as well. Look at society, look at your natural environment and the company itself. So integrated reporting goes much wider, and again brings this principle of looking at the environment in which the company operates into the financial and accounting sphere. And then the third pillar of enforcement is the Social and Ethics Committee. Now, Social and Ethics Committee is a brand new concept that was introduced in the Companies Act. It didn't exist previously, but it becomes a very important tool for corporate governance from a corporate governance perspective. Not all companies have to have a Social and Ethics Committee. Public companies and government-owned entities must have social and ethics committees, and certain private companies who exceed a certain score must comply with that. But the code prescribes that, to the extent possible, all companies should consider having that. And it's an interesting concept, because if you look through Regulation 34 that prescribes what the Social and Ethics Committee does, it again brings out two very pertinent aspects. Number one, it must consider all publications and relevant publications that may be applicable to the company. Now, that would be something like the King Report. So the Social Ethics Committee is obliged to take cognizance of, it's a legal obligation, of a document like this and apply it. And secondly, and this is what I find very interesting, is actually one of the obligations to evaluate the company as a good corporate citizen. That is exactly how it is stated. Now, that means that there is a legal obligation through the Social and Ethics Committee to ensure that the company is a good corporate citizen. Good corporate citizen, as defined in King 4, means that you take cognizance of the whole environment, the stakeholders and everyone that fits together. And therefore, one can unfortunately not look at a document like the King Report, which is, in its own words, a guideline, and ignore it. You have to apply it because the Companies Act requires it, because the Companies Act requires good corporate citizenship, and because obviously on the softer issue side, it is important for a company in that perspective to ensure that it becomes a good citizen. I mean, that is what it is about. But it's important to recognize that, and these pillars work together with each other. Integrated reporting, looking at your environment, the test as to whether or not you took a decision as a director using a rational basis, and you can explain that, and then obviously from the Social and Ethics Committee perspective. If one then turns to things like remuneration and remuneration type of issues within the company, Companies Act itself is silent on how that must be done, but the code certainly does have some specific proposals in respect of how remuneration policy should be determined in the company and how it should be disclosed. It's interesting that the disclosure aspect has thus far been a little bit of an open issue. There's a debate from a legal perspective as to whether or not directors' remuneration must be disclosed in financial statements. It's a very technical argument, but there is a bit of a debate around that. And if you look at King 4 from a corporate governance perspective, it must certainly be disclosed. A policy that sets out how it is determined must be referred to, and the basic principles of that stated, and the remuneration, including benefits and other items, must be disclosed in the financial statements. In fact, the King Report goes even further to say that directors' remuneration must be approved by special resolution of shareholders. So in other words, it must have a 75% vote of shareholders to approve that, showing the importance of making sure that the remuneration policy is a fair one and that it complies with all the requirements of the company within its environment, and obviously that shareholders, who at the end of the day would be the ones that enforce this, are informed and are satisfied with the remuneration policy.
Thanks, Andre. Ansi, I don't know